great pleasure to see all of you this afternoon here on this call, which is our Faculty Works in Progress colloquium series, which is jointly done by the Humanities Center of Universities, and where you are able to be unmuted in order to see speakers, and also especially be unmuted during the Q&A, including video unmuted. That's of course always nice. We also know that at the same time, this is a series where we actually count on people being able to eat at the same time. So if you would rather eat, and Ari, we're thinking maybe you won't be eating, we won't give you quite that privilege, but if you would rather eat while not having your video on, of course, we understand that as well. The series, as I said, is done jointly by the Humanities Center and the college, and we are very pleased that a colleague whose work overlaps a lot with interests that the college has built over the last few years is giving a talk in this series. Ari, you will be introduced. I'll turn to Laurie in just a second. You will be introduced by somebody else, but let me just say that from my perspective, the questions of digital transformation, information ethics, and how those can be looked at in collaborations between those who are in computer science, those who are in law, those are in the social sciences and humanities, are clearly an important area of focus for the university and an important area of impact beyond the university. And so I think the work that you are portraying to us today very much relates closely to a university cluster that is focused on algorithmic bias and those questions of social impact that relate to that. And so it's very exciting, I think, for those of us in CSSH to hear about your work, and we very much look forward to the collaborations between different groups in CSSH, the School of Law, Curie, business, that will move this important set of issues forward to in the future. So Laurie, with that, let me turn to you.
Thank you, Uta. I'm very happy to welcome all of you to our Faculty Works in Progress series, and thank you for being here. As Uta mentioned, Ari Ezra Waldman, our new colleague with appointments in both the School of Law and Computer Science, is himself an interdisciplinary one-man band. His PhD is actually in sociology. So we hold a place for you here. And Ari in particular asked to be part of our CSSH series because he is eager to hear responses to his work in progress from colleagues in our college. So this is exciting, and for the Humanities Center in particular, which I always say is the address for interdisciplinary faculty collaborations. So Professor Ari Ezra Waldman is a leading authority on law, technology, and society. He directs the School of Law's Center for Law, Innovation, and Creativity, and studies asymmetrical power relations created and entrenched by law and technology, with a particular focus on privacy, online harassment, and the LGBTQ community. Professor Waldman was named one of 2020's top 50 thinkers by Prospect magazine. He was in incredibly good company on that list. And he's also a founder of At Legally Queer, a social media project that educates the public about history, present and future of LGBTQ freedom. So his biography is impressive. There's a link to it in the chat. He will speak to us today about privacy law as performance. And before I turn over to Ari, I will just take this opportunity both at the beginning and I'll repeat it at the end to encourage you to come to mark your calendars for the next Faculty Work in Progress in this series, which is by another fabulous new colleague, Angel Nieves, who will be speaking about the spatial histories of anti-apartheid activism, the Soweto uprising, and critical digital platform making. And that will be Monday, March 8th, so 2 weeks from today. So I will repeat that information at the end, but for the moment, welcome Ari Ezra Waldman, and thanks for joining us today.
Thank you so much, Lori. It's really a pleasure and honor to be here. Apologies in advance for the background. The digital backgrounds on Zoom don't really work. Like my head goes in and out, probably because I'm a little too pale, but we're moving. So that's just what's happening. So as I said, Lori and Dean Pointer, thank you so much for inviting me. It's a real pleasure to be here. As a sociologist a sociologist and a lawyer with an appointment in a law school and a computer science school, it's imperative and a real pleasure for me to speak with social scientists and humanities experts who can give me a good perspective on some work that maybe most lawyers and computer scientists really can't. And my work generally is interdisciplinary, and I'm only just started here at Northeastern during the pandemic. So already my experience has been wonderful, but I look forward to meeting a lot of you in person. So I'm just going to, I have a few slides. I'm going to share them just to give us a little, just something to nail down our discussion. And so you don't have to stare at me the whole time. I'm sure there are much more exciting things to stare at. So this project is the end of a research agenda that's culminating in my second book, which is coming out in this next summer, called Industry Unbound. And it's based on 4 years of fieldwork inside technology companies, doing interviews with current and former employees at various levels, various different types of jobs, from computer engineers or software engineers to privacy professionals, all about, and review of internal documents and so forth, about how companies actually do privacy. And what I mean by doing privacy, I mean the practices that are involved, from design, the code, to how they engage, the discourses that they use in meetings and publicly, and also the practical, in this case, and to use the language of this presentation, performances of the law. And that research has led to a series of publications that have been really well received in the privacy law community. I'm really honored and flattered that they have. And this is kind of like the major or the central intellectual conclusion of one part of the book, now out for consideration at some law reviews. So briefly, I'll start with my research questions. There are two. So why is it that all the recent proposals for comprehensive privacy law in the US look roughly the same? Over the last two or so years, there have been approximately 50 new statutes, proposals introduced in state legislatures as well as the US Congress for comprehensive privacy law. The United States doesn't have a comprehensive privacy law. We have these individual sectors at the federal level, like we have a law about health privacy, that's HIPAA, which you all interact with when you ever go to your doctor. We have Gramm-Leach-Bliley, which is about our financial information. We have the Children's Online Privacy Protection Act, which protects some information. It's really a consent-based regime for websites that collect information on children. But we don't have a comprehensive privacy law. But all of the recent proposals for one look almost identical. And that's odd, right? That's odd, especially given the political polarization. And it's also odd that everyone seemed to agree on a particular type of privacy law, which we'll talk about in a little bit. And then the second question, of course, is are these laws actually good, right? Are they actually going to do what we need them to do? And I'll start, I did the animation a little wrong there, but I'll start without hiding the ball, and I'll start with the answers. And my answers or conclusions from this research is that privacy's practices are performative, and they are the ones that have constructed from the ground up what we think privacy law is and should be. So the answer to the question is why they all look the same is because we are path dependent based on how we have practiced, based on the habits that we have developed, that engineers, that management, that privacy professionals, other compliance professionals have habituated themselves to over time, engaging in these practices of privacy law. So the statutes that we have are more reflective as opposed to anything new. surfacing the performative aspects or the performance nature of privacy law practices really highlights what's wrong with these new proposals. They'd be constructed in a way that legitimizes rather than reins in informational capitalism's business model. So a system that is based on rules of the road or procedural compliance, and I'll talk a little bit about what these laws are in a minute, doesn't really do what we need it to do. And there are structural rather than just normative problems with these laws. Okay, so those are the research questions. I told you a little bit about the field work. I'm happy to talk in Q&A about a little bit more about methods if you'd like. I'll get to the substance here. So a little bit of a roadmap. I'll talk a little bit about the literature that this project is based on. I'll give you a little bit of the privacy law background just so we can understand where we're situated. Talk about privacy as performance, then identify those structural problems, and then talk about solutions. So the literature for this audience is probably quite familiar. Everyone is probably quite familiar with How to Do Things with Words from Austin and Irving Goffman's early work. And so I don't really have to go much into that or even Judith Butler's work on performance. But the basic idea, just for those who might not have the same familiarity with this literature, is that our practices are not just practices, they are expressive. They express to ourselves and others in the case of Goffman and Butler, they talked about identity. So Judith Butler is super famous, of course, for arguing that gender is socially constructed by our gender affirming practices. There is no such thing as gender, it's just performed. And our performances as a result, they don't so much habituate under Goffman and Butler's theories, but they do construct, right? Everything starts from performance, and entire legal or socially relevant categories are constructed from our performances. And the other piece of literature that I put here is Lauren Edelman, who wrote a book called Working Law. She's a socio-legal scholar at Berkeley. And without using the terms, without using the language of performativity and performance, Professor Edelman is really responsible for a long research agenda about how the practices of law in the Title VII context. So Title VII, of course, is our federal law that prohibits workplace discrimination on the basis of race, national origin, religion, sex, and based on recent case law, sexual orientation and gender identity. So Lori has pioneered a research agenda in which she described how the law of Title VII, regardless of what it says on the books, right, regardless of the vague statute that says you just can't discriminate, the law of Title VII has been managerialized by the practices of companies on the ground. They've created these diversity offices, and they have these appeals processes, and they have these internal compliance structures that have then integrated themselves into the law on the books. So as a result, you may actually have, if you're a business owner, say you're a law firm, you may actually have no female or no Black partners, but because the practices of law, the practices of Title VII law have socially constructed what we think the law is, the Supreme Court and other federal courts have said, that's okay, you're not running afoul of Title VII because you have these procedures in place, because you have an appeals process, because you have a non-discrimination policy. That is, although she calls that legal endogeneity, and that of course is a classic like law and sociology literature, there's a great similarity to performance and performance literature. Of course, here, instead of our actions creating our identities from the ground up, here, our practices of law are creating law from the ground up. And in previous scholarship, I have compared, or I have expanded Edelman's work on Title VII and managerialism Title VII to show how privacy has essentially become managerialized in the same way. So what is privacy law? Where do we stand? Let's brief brief background and put these literatures together with privacy law. So everyone is familiar, I think, with these kinds of things. You may not read them, but almost every website out there has a privacy policy. And almost every one of them say, we work hard to protect your information. We care about your privacy. Privacy is important to us. Now, these policies are a product of what I'll call the first wave of privacy law, which is called notice and consent. All companies have to do is they have to put up a privacy policy. Those privacy policies have to say certain things. And then we have the individual right that we can exercise on our own to consent to use another or to use another platform. Of course, as I'm saying that, you're listening and you're saying, well, no one actually has effective rights to consent, that this notice and consent policy, whatever you want to call it, is unhelpful, inadequate. No one reads privacy policies. Absolutely right. But unfortunately, that's been our privacy law, particularly in this case, in this country, outside of those specific sectors for 30 years. And even in those specific sectors, a lot of those statutes that are heralded as great privacy protectors are really just notice and consent type laws. Recognizing, I think, that there is an ongoing or growing demand for some change, because we all recognize how inadequate that law is. Over the last several years, as I said, new privacy laws have started to be proposed that do something a little different, right? The rhetoric out there is that laws like the General Data Protection Regulation in Europe, which is the European Union's big comprehensive privacy law, the new law in California, which just came into effect January 1st, 2020, the California Consumer Privacy Act. Everyone is saying that these are super strong, they're strict, they're tough, they're the toughest laws that are out there. Well, that's fine, but what do they actually do? And these laws are not only notice and consent, they build on top of notice and consent a binary structure. And binary is from my colleague Margot Kaminsky, she wrote an article about binary governance. These are forms of the new governance scholarship called collaborative governance. They combine a series of individual rights to our data, meaning rights of access. You can access your information, transparency. You can correct, you can ask companies to correct wrong data about you. You can even have rights to delete under some statutes. Portability is moving it from one company to the next. You don't want Google to have any more of your data, you can move it to Microsoft or Bing. The second half of all of these laws is a compliance element. And it creates this public-private partnership between public institutions like the Federal Trade Commission and regulated entities themselves, in which companies, the information industry, are conscripted as engaging in their own ongoing monitoring. And they use impact assessments, audits, self-certifications, codes of conduct that are created by industry. They hire offices, like the law will say you have to hire a privacy officer and so forth. Rights and compliance. And it's kind of remarkable that almost all of these laws introduced by Republicans and Democrats in blue states and in red states all pretty much look the same. And other scholars in socio-legal studies have suggested that, well, it's just the GDPR that's doing it, because the GDPR is a binary system. It has rights and the rest is compliance. So we are just mimicking what the European Union has done. And because they're a large norm generator, because it's a significant market, and because of this rule that they have that European data can't go anywhere else unless these other countries have adequate levels of protection. So if we want to do that, if our companies want to be able to use and mix European and American data, we have to have adequate levels of protection, and notice and consent doesn't do that. There are other arguments that, well, it's California that's the norm entrepreneur, but I think all of that has misread the history. It has also misread the ways in which we socially construct from the ground up what we think law is. So when it comes to the rights, right, we're all familiar with individual rights to privacy. Everyone has seen these toggle buttons. It's off now, you move it to on, it turns green usually. And these things are our consents. We see a lot of them. We may have 200 or so apps, maybe if we have 50 or so apps on our phone, we have on average no fewer than 350 of these toggles to engage in if we actually wanted to do it app by app. If you add in your websites, every website you go to in a week, you have another several thousand of these that you would have to go through. The notice and consent, which, you know, this is kind of a design manifestation of notice and consent, is an individual rights-based regime. So is agreeing to a privacy policy that you obviously never read. Also is, by continuing to use this website, you agree. So we are used to a privacy law system that is based on individual rights. So it should come as no surprise that we stick to individual rights. And when we think about new privacy laws, there is no, we are used to it. And there are performances here. So when I talk about, you know, practices that are expressive to the self and to others, you know, every time we click this button, every time we click agree, every time we even engage in, you know, some type of back and forth with a company about what we want with our data, as the philosopher Gordon Hall has argued, this is kind of like a Foucaultian technique of power. It habituates us into making us think that privacy is a self-regulatory regime, that we have individual rights, that privacy is an individual right. And we can talk a little bit in the Q&A about how this is deeply embedded in discourse as well, both from industry and academia, about the individual nature of privacy rights. But these are also super old, right? There's nothing new about this. These lists, this list of five principles was published in 1970, originally published in 1973 by the Housing, Education, and Welfare Department. And the rights that are in these supposedly super tough vanguard privacy laws are as old as the HUE report, right? Notice and consent didn't amplify them, but these new ones do. And we have been seeing practices inside technology companies for years that have recognized access and deletion and correction. They haven't publicized them because the law hasn't required them to, but companies and compliance professionals are deeply embedded in these practices. So it should come as no surprise that practices that habituate us into thinking that our identities are as self-governing privacy entities, and that companies habituate themselves or create this idea that privacy is an individual right to be exercised by users. It should come as no surprise that that's what statutes say as well. When it comes to the compliance matters, this is even more performative. It has been a long time since, it has been over 10 years since the FTC first said that a company has to develop, the company that they've investigated has to develop a comprehensive privacy program, which includes hiring a chief privacy officer, which includes audits and assessments, which includes all the compliance tools that are supposedly vanguard in these new laws. The FTC has almost never litigated anything related to privacy in its 30-year history of privacy investigations. It has come to a conclusion in 271. Others have been ignored or dropped that we don't have any record of. But of the 271 where there's a record, only 3 have been litigated. FTC's practices are to settle and to agree to come to what lawyers call consent decrees. It should come as no surprise that based on this practice, that the laws in the states and at the federal level actually require the FTC and state attorneys general to first come to a settlement before they actually litigate. And that is entirely the product of this being a practice, a pattern and practice of privacy for more than 30 years. The FTC has always considered itself, it is written into its mission that it is more of a partner rather than a regulator of industry. And I've been inside these meetings where the FTC sees itself as trying to help industry, facilitating innovation. Those practices, even though the FTC is technically, the law in the book says they are a regulator, in practice they are facilitators. In practice they see themselves as partners. It's something that I saw during my field work. That practice has socially constructed what new privacy laws are, because it is integrated into these new privacy laws that the FTC has to work with industry. It has to work with industry to issue opinions. It has to work with industry and get their input before they can issue any settlements or any opinion documents or any statements of what the law is. Assessments. These companies have been engaging in on the ground audits and assessments that are pretty weak. They're called attestations, in the sense that it's kind of an audit that's based entirely on executive attestation. So I've actually seen some of these in person, redacted, where the audit form will say, are you in compliant with section 3.2 of the 2012 FTC consent decree? And then the answer will be see exhibit I, and exhibit I is a letter from the company executive saying, we are in compliance with section 3.2 of the FTC consent decree. And then there's just a form letter in that regard. There's no proof. And auditors never do that proof. That practice, and I've written about that as part of the managerialization of privacy law, that practice of assessments of executive attestation has become now part of these new privacy statutes. They're not audits, they're explicitly assessments that are in new privacy statutes. And we also know that that is explicitly based on industry input, because we have transcripts and because we have reports from staff at the state and federal level saying that this industry has come talk to them about how these assessments work, and that has translated directly into the language of new statutes. And hiring a CPO, we talked about this already. So this argument is, however, not just about we see it practiced before and now they show up in statutes. That doesn't necessarily mean it's performative. That just means that they could be copying what we've gotten used to. But what shows, I think, that what adds credibility, or what adds some evidence that these practices are performance, is that when I've talked to FTC commissioners, FTC staff members, compliance professionals, middle management, product managers inside companies, I have the recurring response, the single most common response that I received in any of my research was, well, that's what privacy is. And every time people would respond, say, well, that's what we do, or that's what privacy is. What do you mean? And when I would propose, well, what about not collecting information X, or not collecting sexual orientation information? And they said, well, they would say, but that's not what privacy law is. Privacy law are these rules about what we do when we collect it. We have to have audits, we have to have policies, we have to have procedures. And it's remarkable how often I heard that response, not just from management, who you would think would use that cynically, right, or disingenuously. And I'm being very conscious here that Judith Butler doesn't talk about performances only as ersatz. They're not just cynical performances. You might argue, you might say, well, we can dismiss executives saying that because they have a financial interest in ignoring or minimizing privacy law. But you have people who are privacy professionals who see themselves as privacy advocates. They put on their LinkedIn profiles that they are privacy advocates, that companies hire them because their companies care about privacy. These are people who deeply are interested in and who care about privacy in their own way. But the way that they care about privacy has been habituated by the practices that they have been engaged in while being privacy professionals inside companies. That part of that, and there's other evidence, but that inability to recognize how practicing privacy law the way industry wants us to have created our identities, or have created our vision of what privacy law is, to me shows that there is performativity here, that practices have created what we think privacy law is. So what are the problems? The performative aspects of the rights and the compliance elements show the problems, or the systemic or the structural problems with privacy law as constructed. The rights section, informational capitalism's harms are not individual level harms. They're population level harms. Individual rights cannot address things like targeted advertisements we see are in fact based on information that they gather from us. We are conscripted the moment we turn on the internet. We are conscripted into a population level system that extracts information about us to make decisions about what other people see. Our consent to that says nothing about other people's consents to being part of that system. There are also non-users, right? So more active non-users. If anyone's ever used 23andMe to find out their DNA, which is super fun, right? It's not always accurate, but it's super fun to find out where you come from. But your consent to that does not operate as consent to your cousins or your sisters who share some of your DNA, right? So individual level consents or individual level rights, which have been constructed as what privacy law is completely mismatched to the structural problems of informational capitalism. And what about the compliance stuff, right? This on the side of the slide is quite literally what a privacy impact assessment looks like. It's really just a checkbox little chart that someone made in Microsoft Word in 2 columns. And there are other designs, of course, but this is the standard. Reliance on internal compliance performatively constructs inadequate public institutions. So this is a big problem because new privacy law is supposed to be what we call collaborative governance. It's supposed to, which is this middle way of a partnership between public institutions and regulated entities, the middle way between self-regulation and command and control that is still supposed to operate somewhat strongly because there's always this backdrop threat of the government coming in with a punishment if you guys in regulated entities don't do what you're supposed to. That's really what distinguishes it from pure self-regulation, because the regulated entities themselves are doing all these compliance monitoring on their own. But if you think about it in terms of performance, and you think about it, performances as endogenously creating from the ground up what we think the law is and should be, then you recognize that creating legal institutions like this that use or rely on individual companies' compliance departments, you are therefore socially constructing public institutions as reliant on companies to do part of their work for them. And that's why we see so many, and it's part of the kind of neoliberal approach to governmentality and managerial governmentality in our system, in that so many public institutions are now reliant on the auditors that are privately hired, or the human power that is privately hired, or the compliance that's done, or the codes of conduct that come from elsewhere. And because if you see that, and if you see that as performative, you're going to create this impression that public institutions don't need any more funding or don't need any more human power because they have the private institutions to rely on. So the danger is that by performing privacy as a public-private partnership, you are performing public institutions, you're performatively creating public institutions that are inadequate. That takes away the backdrop threat, right? They can't operate as a backdrop threat, which then collapses collaborative governance into self-regulation. And of course, that's what companies want. They know this is going to happen. And that's why they're eager in saying, we want the right regulation. Mark Zuckerberg says we believe in privacy regulation, but the right regulation. And that's why they're super cool with this stuff, why there's no pushback against collaborative governance and compliance in the statutes, because they know that it's just going to collapse down to self-regulation. So again, taking a model from Butler and even Foucault about, so what do we do about this? Well, you can perform resistance too. And this is, I think, this is the hardest part of this project, because it's really easy. I mean, having studied this, and having come up in like science and technology studies and actor network theory, I'm trained to follow the actors, right? I'm trained to follow what they do. But thinking about how do we step out of neoliberal managerialism and think about radically different governments? I mean, I'm 40 years old. I grew up, my first president was Reagan, and it's hard for me to, I mean, I was born while Carter was still president, but my first president was Reagan. I have only known of deregulatory neoliberal government institutions. So I have to admit, this is hard. I'm taking a law and political economy approach, which is a law and political economy is a kind of an updated progressive era legal realist approach that also takes into account intersectionality, liberational principles. The idea being that law is not separate from the economy. Law creates and politics creates economic relations. So, so what do we do about it? Well, performance theory gives us a vision for performing resistance. Thinking about it in performance terms shows how all the other proposals for privacy reform are not helpful. Privacy rights of action, private rights of action, you know, us suing instead of just the FTC suing, okay, that's fine. But if we just turned on that light switch today and started to be able to sue companies, well, we've already allowed this in certain circumstances, but if you go through the arguments that these companies are making, the rights compliance binary allows them to say, well, you consented. You said, you clicked on the button, you said, yeah, I agree. And transparency and consent is still part of these rules. So you have companies saying, you have no privacy rights on our platform because you consented, even after they have created complex compliance systems. Sarbanes-Oxley is a law that was passed after the financial collapse. It's about banking and accounting firms and how we do accounting to prevent another financial collapse. What about Sarbanes-Oxley type audits, which require independent audit committees, liability if executives lie? Yeah, fine, but audits are also on the periphery of the regulatory state. That's a phrase from my colleague Julie Cohen at Georgetown in her book, Between Truth and Power, which I really recommend. And more audits is also a performance that's going to, again, construct public institutions as inadequate. So what about some other radically different performances? Because that's all we need, really, right? We need some radically different performances to start constructing law in just a different way. And what's great about this is you only need one. Like, you need a progressive state that's going to just jump out ahead and do something different to change the discourse, to change the Overton window. So obviously, we need radically improved funding for independent public institutions here. We need a total break from our neoliberal approach to managerialism. What about thinking about privacy rights, not in terms of rules about what you do with data, but what about civil rights, right? We don't have in the United States a human rights discourse, really. I mean, maybe we should, but we don't have it right now. In constitutional law, however, we have a robust civil rights discourse, regardless of what Trump judges want and Republican judges have wanted over the last 30 years. We still have a robust civil rights agenda. Thinking about privacy rights in terms of civil rights, in terms of the things we are entitled to, and the protections we are entitled to, as opposed to rules of the game for data use, that would create very different practices on the ground. Not saying that there's no role for compliance professionals, but just different practices. What about, instead of consulting industry when we write legislation, what about consulting the marginalized populations themselves who bear the most burden, bear the most risk from privacy, from the data use? What happens if we had inside offices victims of non-consensual pornography, victims of technology-facilitated intimate partner violence, victims of data misuse, other forms of data misuse? These are people, mostly women, persons of color, queer people, who have perspectives on data use that your run-of-the-mill 70-year-old white dude in Congress doesn't, right? Not saying that we don't also want perspective from your run-of-the-mill white dude in government, but we also want queer people, we also want women, we also want persons of color, Black men and women who have been the subject of police surveillance. Why aren't they in the room when we're writing privacy law? And then finally, we should think way outside the box. Tech worker unionization. Why not think about, one of the problems is that we don't have access to independent research about, real independent research about AI, about its effects, about what it does, or its discriminations, its harmful effects on society. Google just fired in the last 6 months 2 of its leaders of its AI ethics department. If tech workers were unionized, if independent tech workers were unionized, that would be a lot harder to do. It would also keep companies' feet to the fire. Even environmental protections. You know, it's outdated to say that the internet is a series of tubes, but these companies have been laying literal wire underneath the oceans for decades, and they have an environmental impact. And we've exempted them from a lot of environmental laws because of innovation, or because somehow the information industry is somehow exempt from all sorts of protections, all sorts of accountability. But now we have what about a new environmental protections that would limit, pull back on what companies have to do? But a lot of these things make you think that they're a little outside privacy law. Well, that shows you how outside of how myopic our privacy law discourses have been. And I think only by understanding privacy law as a product of performance will we recognize that we need new performances way outside the box. And I'll just end there. Hope I didn't go over too long. I think I did about a half hour.
That was perfect. It was great. We have about 15 minutes for responses. I myself have, you know, I thought that was incredibly interesting and clear. And I have lots of questions, but I will read and invite questions from those of you who are with us. Thanks for the clapping. Sari, do you use the hand raise function? Raise your hand. Actually, if you're on the screen, we can all see each other.
Lori, would you like me to call on people, or do you want to manage?
I'll do it. I'll feel them in the order in which I see them. So Libby first. Libby and then Uta.
Hey, Ari, thank you. That was great. I'm so glad you're here. Although I don't know if you're here yet, maybe you're still in New York, but I'm so glad you're on the team. It's great to have you. So I loved every word except one. And so I just want to raise the one moment when I slightly winced. And that was approaching this as a civil rights issue. Because I want the project to take on board the critique of rights that I think kind of precedes the, you know, law and political economy trend that we're all currently sailing along on, including me. I'm doing that too. But I do think that that the critique of rights and the, you know, when I think about how many other environments rights are the guiding discourse and still radically fail for consumers, for the people who we want to protect, for, you know, and so on. So I just wanted to sort of poke at that a little bit, and you don't have to respond. You could collect some and respond if it occurs to you, but I just wanted to lay that out as one thing I want you to be wary about.
I think that's really wise. There is a sense that privacy law has to crawl before it can walk, or even just turn over on its belly before it can crawl, right? So there are steps that we have to take. So in some ways, I can argue that a civil rights agenda for privacy is a big step forward. But I wanted to take your point and totally agree. And in fact, in the final chapter of my book, I do take on the rights critique and saying that the problem that we still have is that we still conceptualize rights in an individual basis. And if we start to think about privacy and start to think about data issues in terms of trust, like my first book and like other people do in terms of these social values, then we have more to deal with. So for this narrow project, again, I take value in, you know, a little step forward. But I think going forward, now that this research agenda has kind of ended, now I think it's time to take on privacy rights more generally. So you and I will talk more about that. Thank you.
Susanna.
Loved it. Fabulous. Wonderful talk. Wonderful. I have a million questions, but I'll just do one, which is, you know, one of the things, and I think it might be an issue with sort of hanging so much on the performativity discourse. One thing that I kept thinking of is the question of ideology and questions about sort of ideology preceding. I mean, this has been a debate, you know, with Butler's work as well. I mean, ideology, you know, in some ways preceding, in a normative sense, preceding the performance, that the ideology enabling performances to come into being, even have sustenance. So I think particularly, and I wonder what you think of this question of, you know, even the conceptualization of what is defined as private. All I could think about, of course, as a feminist scholar is the public-private divide. And, you know, so you think of sort of what does it mean to perform privacy with embodied bodies that have already been marked as belonging to one of those realms, the private versus the other, the public, right? I think the question of, I mean, you opened talking about this, the ways in which, for example, the sort of violative nature of much of internet discourse against women in particular. And of course it's sexism and misogyny, we know that, but it's also, it seems to me, because women's privacy is seen as more ability to be invaded. That's part of the performance of themselves as women, right? Is that we are there to be invaded. So in other words, I guess I'm saying that there's a way in which you talk about performativity that strips it of too much, for my taste, I guess, strips a little bit of its ideological valence. Does that make sense to you?
It does. It does absolutely make sense. And I think that is a product of this, I think it's a product of this talk, because in the book, I talk a lot about the constructive ability of discourse to kind of create this ideology of privacy that essentially is the groundwork for this, right? This doesn't exist without so much work being done, so I'm thinking, I frame it in terms of Foucaultian discourse, but I also frame it in terms of the history of privacy discourse, which associated, even back in the day, back like in classical times, which associated like certain parts of the house as the public part, and that was the male part and the rational part, and the parts of the house that were feminine, and that was the private and non-rational, where like emotional stuff or nurturing happened, right? Or where sex and children occurred. So all of that, I think, is wrapped up in how we've originally conceptualized privacy. And to conceptualize privacy in terms of what industry wants is like, you have control over your information. It is, in one sense, it's a very easy thing to manipulate, right? Because you can say that once you've consented, once you've clicked that button, you have no control over it. But it is also it's also a window that allows industry to absolve itself of responsibility for data use that harms marginalized populations, because it's very easy for them to say, well, to a woman or to a queer person or a person of color who's harassed on Twitter, well, just stop using Twitter, right? Or just, this isn't a problem with us because you have control over what happens to you. So obviously that is bonkers and completely disingenuous. But I 100% agree that there is an ideological part to this. The narrowness of this is really more about once that foundation has been set about what we think privacy is, which for industry has been stripped of the normative, of the important values, the moral valence that you suggested. For industry, it's been stripped of that, then this is what we get. So I would love to talk more about it and maybe send you a draft of that chapter to see what you, if you feel that I've done a good job there.
Love to see it. It's so interesting. It was just
excellent. Thank you. Thank you so much.
There are lots of questions here, Ari. So I want to suggest that given the shortness of time, that Angel, Uta, and I serially present our questions, and then you address as much as you can manage in the time we have, knowing that this is the beginning of a long collegial conversation.
Absolutely.
Angel.
Thank you.
Thanks so much, Lori. I'm looking forward to speaking with you more, Ari. We've got lots of things to discuss in overlap, particularly around rights and the internet. But I was wondering if you might be able to talk, and this is probably a much bigger question than you could handle in just a couple of minutes, but how Blackness plays a role in issues of online privacy. And I'm wondering if, when you discuss performativity, if looking at race, Rod Ferguson and others' work as a way to perhaps mitigate some of the challenges when sort of trying to work out some of the specifics around access and who has the ability to even take part on websites and to sort of in these ways. And I'll leave it there. Thanks so much. Great.
Thank you, Angel.
And Uta.
Hi, Ari. Like everybody else, I also found the talk incredibly generative and interesting. And at the same time, I think I had a little bit of a hard time, partially because, I mean, I sort of was astonished when you said it was narrow in some sense, because to me it was touching on so many different issues. And so I have a couple of comments and then maybe a question that you don't really want to answer at all. But you alluded to the fact, and I think Susanna's question in a sense was going in that direction as well. You were sort of using performativity in multiple ways during the talk, and there was too much slippage for me because you know, the Butlerian use of performativity and performance is really quite different from the ways in which you use the terms of performance in order to critique industry behavior, right? Because she really uses it in a way in order to say something that is much more about denaturalizing categories and the potential for change. In any case, to me, it just seemed like those kinds of different uses needed to be marked even more. And then I think I really wished for you to go through one of your examples in more detail. So for example, so just if you think about a talk for future audiences that are perhaps as, you know, I mean, you have from legal scholars to humanists here, so it's maybe not that broad, but that is relatively broad. I think what you are doing would be even more clear to an uninitiated audience if you actually went through one of your examples in detail. And there too, I then had the question that is similar to Angel's question, whether in that such a talk, you should actually do what you said at the end. What would it mean actually to have the marginalized voices in the conversation or even have them at the center? So if you started out with that and then told us everything that is not being addressed in the current frameworks, it would probably become even more vivid to us, because as it was, I too got stuck on, well, you know, historically and now privacy, these are always such complicated constructions that surely have a lot of ideological power. But of course, they were never as purely gendered, even in the way, you know, you summarized it in response to Susanna. So in any case, a case study in detail I would love. And I will say this is probably a silly question, but before you made use of Facebook towards the end, I really wanted you to tell me why exactly Facebook is doing this major advertising campaign that even someone like me is now constantly exposed to. And of course, I have my own answers, allegedly asking for government regulation. And you partially gave me an answer because you actually explained to me that in this managerial mode, there's pretty little at stake for these companies in new laws. And that's obviously pretty, that obviously explains why this is largely a public relations move, which I had already suspected.
Great,
so,
thank you.
Ari, my thoughts follow exactly from Uta's. I also thought you used performative in two distinctly different ways. The gap between Austin and Goffman and Butler, and I'm accustomed to thinking in psychoanalytic terms, is really a distinction between conscious and unconscious self-enactments, and that seemed a critical difference for me. But also, I you know, because I'm focused on the psychological, what I wondered about is how and if the law could address the coercive element of needing to click on acceptance of things you may not accept because of the unwillingness to deprive yourself of access to what these companies offer us. So I feel stress every time I consent. I don't want to consent, but I feel coerced to consent because I need this thing. And I also don't know what I'm consenting to, as you keep saying. So I feel like this aspect of the sort of psychological construction of a population that's being habituated into doing something they don't want to do. I mean, I feel my cortisol levels go up. I want to, you know, I just wanted to make that as a kind of psychological point, and finally, and a little out of left field, is I wondered if there's a conflict between our need for privacy, especially around identity categories, and inclusion and diversity mandates. Like, you have to know who people are to include them at the same time that we want to protect people's right not to be known.
Yeah, these are amazing questions. With only 3 minutes left, I take them all, and I think there is, and I had this comment before about slippage between, two definitions or two approaches, because they're not the same, and they're, for the purposes of social construction, I think I just need to make it clear. I'm really relating that as a way for lawyers to understand what's really happening in the Edelman endogeneity idea. So I take that, and I know I have to fix that. Uta, your suggestion for making the presentation better now when I start doing like my book talks, I think that's a really good idea. So absolutely. But just in the last 2 minutes, I want to go just briefly in reverse. So Lori, I've experienced that conflict. I'm chair of the Privacy Law Scholars Conference. So it's our biggest conference in the field. And we have a race problem, and we need to learn who our community is. But we have this issue, we want to collect demographic information, but we also want to protect people's privacy. And then it becomes like intricate details about how we ask the question, right? So that reminds me, though, that there is a performative aspect to this, because the way we ask the identity question is going to be part of the discourse, and it's going to, when we look at how other people ask the diversity question, it becomes part of our discourse. So I'm wrestling with that as well. In terms of why Facebook is doing this, Facebook, I think you're right that this is kind of this is part of a bigger activity, Uta, that Facebook and big tech are engaged in. They are saying no to regulation at the state level because they want uniform federal regulation. And then they're saying, okay, we want federal legislation, but only if it's the one we want. But part of my point is that they're less concerned about what the statute says, because they know that they can undermine it inside the company. So that's why I don't think they actually care as much, because not only because they have it from multiple angles, the lobbying, the input, the whatever, but they care less about, because the practice matters, right? So there's that classic line from Congressman Dingell, who said, I'll give you control over the substance, you give me control over the procedure, and I'll beat you every time, right? So that's what I think what the companies are focusing on. And Angel, how does Blackness play a role in online privacy? There are other smarter people who have focused a little bit more on that. And my work has focused a little bit on the queer aspect, but I look forward to more conversations with you about that. See, we're at 1 o'clock, but thank you very much, everyone. I really appreciated your feedback and the opportunity to share this with you. Please don't hesitate to email me, a.waldman, Northeastern. So I look forward to meeting you all in person and learning more from you at some point.
As do we. This was just a lovely introduction to you and your work. And we know we'll hear more from you about this and other things. Those of you who remained, thank you for staying. I know some people had to leave for class a little bit early, but in the, again, a reminder that Angel Nieves on March 8th at the same hour will talk to us about the spatial histories of anti-apartheid activism. And I will just take the prerogative of my multiple identities, since we're under a little bit of pressure here to get the word out. Also on March 8th at 5 o'clock, we have a tremendously interesting program, our annual Ruderman Lecture, and you'll get more information about it, but it's called Trauma, the Jewish Experience and Lessons for Post-COVID Mental Health. Our 3 speakers, Rachel Yehuda, Eva Fogelman, and Danny Brom, are really world-renowned experts on trauma and resilience. So I hope to see you there. Thank you all for being here, and see you soon.